Welcome to episode 44 on the Law Report. In this episode, I'm going to deal with the judge's rules. Nothing that I say in this episode shall be construed as legal advice. For legal advice, please contact an attorney of your choice. A viewer to this channel asked me to do an episode on the judge's rules, and notwithstanding in the Turks and Caicos Islands, the judge's rules are being treated as if they belong to the age of the dinosaurs. I decide to oblige the viewer. The judge's rules are an important cornerstone of the Commonwealth and, by extension, the English jurisprudence. And as a common law jurisdiction, they are very important to the Turks and Caicos Islands. The judge's rules are a set of guidelines about police questioning of suspects and the acceptability of any resulting statements and confessions as evidence in court or at trial. They were originally prepared for police officers in England. The rules and their successor documents have become a part of the legal procedure, not just in Britain, but in the Commonwealth, especially in common law jurisdiction. The judge's rules were replaced in England and Wales by Code C of the Police and Criminal Evidence Act of 1984. The rules were first issued in 1912 by the judges of the King's Bench to give English police forces guidance on the procedures that they should follow in detaining and questioning suspects. The rules were intended to halt a divergence in practice that had developed among different police forces and replace all the informal guidance such as Sir Howard Vincent's Police Code and Manual of Criminal Law. The judge's rules are not rules of law, but rather rules of practice for the guidance of police officers, setting out the kinds of conduct that could cause a judge to exercise his or her discretion to exclude evidence in the interest of a fair trial. As Justice Lawrence explained in the case of the King and Voisin in 1918, the rules were drawn up due to a request from the Home Secretary as guidance for police officers. These rules have not the force of law. They are administrative directions, the observance of which the police authorities should enforce upon their subordinates as tending to the fair administration of justice. It is important that they should do so, for statements obtained from prisoners contrary to the spirit of these rules may be rejected as evidence by the judge presiding at the trial. The rules allows for police to question any person with a view to finding out whether or by whom an offense had been committed. It requires police officers to give a caution when they have enough evidence to suspect that a person has committed an offense. It requires a further caution when a person is charged, and it prohibits questioning after charge, save in exceptional circumstances. It requires a record of questioning to be kept. It gives guidance and the best way to record a formal written statement. The rules also include administrative guidance on access to defense counsel and on questioning of children and foreigners. 5 further rules were added to the original 4 rules in 1918, and the rules were further explained in 1934 in a Home Office circular. The rules were reissued in 1964 as practice note, the judge's rules. I will be back shortly to discuss the rules themselves.
Good afternoon, Jason Kagos, as the Commissioner. It's a brief update. I'm in Dockyard and Providenciales. We've had an incident in here within the last hour which resulted in what we believe to be a police-involved shooting. I can tell you now that one person, member of the community, is deceased and another is in police custody. So this is an evolving incident which is now being investigated, and we'll update you more later on today.
So let's discuss the rules. Rule 1. When a police officer is trying to discover whether or by whom an offense has been committed, he is entitled to question any person, whether suspected or not, from whom he thinks that useful information may be obtained. This is so whether or not the person in question has been taken into custody, so long as he has not been charged with the offense or informed that he may be prosecuted for it. Rule 2. As soon as a police officer has evidence which would afford reasonable grounds for suspecting that a person has committed an offense, he shall be cautioned, or that person shall be caused to be cautioned before putting to him any questions or further questions relating to that offense. The caution shall be in the following terms. You are not obliged to say anything unless you wish to do so, but what you say may be put into writing and given in evidence. When, after being cautioned, a person is being questioned or elects to make a statement, a record shall be kept of the time, the place at which such questioning or statement began and ended, and of the persons present. Rule 3. Where a person is charged or informed that he may be prosecuted for an offense, he shall be cautioned in the following terms. Do you wish to say anything? You are not obliged to say anything unless you wish to do so, but whatever you say will be taken down in writing and may be given in evidence. B. It is only in exceptional cases that questions relating to the offense should be put to the accused person after he has been charged or informed that he may be prosecuted. Such questions may be put where they are necessary for the purpose of preventing or minimizing harm or loss to some other person or to the public, or for clearing up an ambiguity or a previous answer or statement. Before such questions are put, the accused person should be cautioned in the following terms. I wish to put some questions to you about the offense with which you have been charged, or about the offense for which you may be prosecuted. You are not obliged to answer any of these questions, but if you do, the questions and answers will be taken down in writing and may be given in evidence. Put and answers given relating to the offense must be contemporaneously recorded in full, and the record signed by that person, or if he refuses, by the interrogating officer. C. When such a person is being questioned or elects to make a statement, a record shall be kept of the time and place at which any questioning or statement began and ended, and of the persons present. Rule 4. All written statements made after caution shall be in the following manner. A. If a person says that he wants to make a statement, he shall be told that it is intended to make a written record of what he says. He shall always be asked whether he wishes to write down himself what he wants to say. If he says that he cannot write, or that he would like someone to write it for him, a police officer may offer to write the statement for him. If he accepts the offer, the police officer shall, before starting, ask the person making the statement to sign or make his mark to the following. I, and the person should state their name, wish to make a statement. I want someone to write down what I say. I have been told that I need not say anything unless I wish to do so, and that whatever I say may be given in evidence. B. Any person writing his own statement shall be allowed to do so without any prompting, as distinct from indicating to him what matters are material. C. The person making the statement, if he is going to write it himself, shall be asked to write out and sign, before writing what he wants to say, the following. I make this statement of my own free will. I have been told that I need not say anything unless I wish to do so, and that whatever I say may be given in evidence. D. Whenever a police officer writes the statement, he shall take down the exact words spoken by the person making the statement, without putting any questions other than such as may be needed to make the statement coherent, intelligible, and relevant to the material matters. He shall not prompt him. E. When the writing of a statement by a police officer is finished, the person making it shall be asked to read it and to make any corrections, alterations, or additions he wishes. When he has finished reading it, he shall be asked to write and sign or make his mark and the following certificate at the end of the statement. I have read the above statement and I have been told that I can correct, alter, or add anything I wish. This statement is true. I made it of my own free. If the person who has made a statement refuses to read it or to write the above mentioned certificate at the end of it or to sign it, the senior police officer present shall record on the statement itself and in the presence of the person making it what has happened. If the person making the statement cannot read or refuses to read it, the officer who has taken it down shall read it over to him and ask him whether he would like to correct, alter, or add anything and to put his signature or to put his mark at the end of the statement. The police officer shall then certify on the statement itself what he has done. Rule 5. If at any time a person has been charged with or has been informed that he may be prosecuted for an offense, a police officer wishes to bring to the notice of that person any written statement made by another person who, in respect of the same offense, has been charged or informed that he may be prosecuted, he shall hand to that person a true copy of such written statement, but nothing shall be said or done to invite any reply or comment. If that person says that he would like to make a statement in reply or starts to say something, he shall at once be cautioned or further cautioned as prescribed by Rule 3A. Rule 6. Persons other than police officers charged with the duty of investigating offences are charged offenders shall, as far as it may be practicable, comply with these rules. I will do part 2 in another episode where we'll deal with the administrative directions and interrogation and the taking of statements. I do feel like a dinosaur going through this because these rules are not followed to the letter in the Turks and Caicos. Here is where I will leave this episode for today. I thank you for watching and I will see you in another episode.